Your Honor, in light of the juror misconduct or the alleged juror misconduct.
So here's where it begins. She starts it out with, in light of the juror misconduct, and then she changes it to alleged juror misconduct. And what she's referencing is she believes the juror knew about her prior convictions or maybe Googled her or something to that effect prior to convicting her last trial. And now she's about to let the judge have it.
Your Honor, in light of the juror misconduct or the alleged juror misconduct, I have to object to us having so much information go out about my personal information in that jury questionnaire. Do you not think that was a problem?
What personal information?
The state versus Lori Daybell.
It's the name of the case.
Yeah, you don't put that on anyone else's question.
He's like, yeah, that's the name of the case.
Yeah, or one other person that's ever had that questionnaire ever put out with their name on it. They just don't do it.
Do it in every trial I've done.
Then the people are just going to Google it, and then we're going to have the same exact problem we had getting a jury for that case. We're going to have this.
Once again, Lori Vallow just doesn't get it. She just doesn't get it. But her case is high profile. It's very different. But to every client and every defendant, their case is the only case. Their case is the only case. And they act like they may know what other cases are like, but they just don't.
Then the people are just going to Google it, and then we're going to have the same exact problem we had getting a jury for that case. We're going to have the same exact problem.
Are you done? Are you just going to keep? Okay. How do we screen for if people have heard about you if we don't include your name?
He's like, are you done? Are you done? Stop interrupting me. Are you done? How are we going to know? And this is where she doesn't know. You actually want it to be like this, Lori. You want them to Google you and tell us that they Googled you when they show up. That's what you want. It's good for you. We want to know the people that have Googled you so we can strike them. As opposed to not telling them your name. They show up, they see you, and they're like, oh, that's who I think it is. And then they hear your name. And they're going to hear it throughout the trial. And they're going to go home every night. So if they're going to Google you, we'd rather find out now before we pick them and put them on the jury. But she just doesn't get it. Yeah, I get it. I get it, Christy. I'm sure a lot of judges have thought it as well.
You have a response to that?
I'm just saying, you gave them the name and they're just going to Google it.
They're instructed not to Google it. All right. And if you'll recall, when we had all the jurors come in person, one of the first questions I asked them in the afternoon was, who has looked up this case since you filled out the questionnaire? And we had 2 or 3 people raise their hand, and those people were excused. So I have to include your name to screen out for the people that know about your case. And we released about 100 jurors last time because of their answers to that.
That's the
If we
point.
don't include your name, that's 100 extra jurors we have to go through in person and ask if they know you. And in fact, that increases the risk of tainting the rest of the jury pool if we have someone stand up and say, yeah, I know about her case in Idaho where blah, 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 in front of the rest of the jurors.
He's like, blah, 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 because I don't really want to say what you've been convicted of, Lori. But he's 100% right. Here's a shocker to some people like Lori Vallow. We've done this before. We've made mistakes in the legal realm, in the criminal justice system. So we create rules and processes and procedures to make it more fair. And this is one of them. This actually helps you, Lori.
That'll burn the whole panel. We'll have to start over. So I'm going to include your name in the questionnaire. I don't think there was any other personal information or background information about you in that questionnaire other than your name. So was there any other issues you had with the questionnaire?
No, Your Honor.
So the schedule will be, we'll meet
That's
1 p.m. to go over those answers on the 29th. On the 30th, we'll meet at 10. We'll have walk-in jurors that morning that will fill out the questionnaire. And then the people that survive our screening on the 29th, and those that survive the morning of the 30th will come in the afternoon of the 30th. This will be back in the courtroom we were in last time, 5D of the South Court Tower. Again, I expect to seat that jury at some point that afternoon. And then we'll plan on going Monday through Thursday, June 2nd to June 5th, then June 9th to June 13th, and if need be, June 23rd.
Your Honor,
Yes.
I have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal?
She's like, I shouldn't laugh. I shouldn't laugh. It's not funny. It's very serious stuff going on. It's late though, okay? It's like past my bedtime. But it's like the judge is just trying to like get this thing going to trial. And she's like, you know what, Your Honor? I'm going to have to do it. I'm going to have to ask that you recuse yourself because you have a personal bias against me. It's like, well, did all the jurors that convicted you of ending your husband's life a week ago have a personal bias against you? Like, does everybody have a personal bias against you? Just because you're being convicted of crimes you committed does not mean people have a personal bias against you. And it's like, I'm telling you why I'm ruling against you every time I rule against you. Do you realize there are deadlines? Do you realize there are rules? Do you realize I have given you the opportunity to extend those deadlines and you don't want to? Do you realize you could have a lawyer and you're choosing not to? You're creating all of these issues. Lori Vallow, Daybell, excuse me. You are creating the issues you're complaining of. I just have to give answers to questions. You're not making good arguments.
Then June 9th to June 13th, and if need be, June 23rd.
Your Honor,
Yes.
I would have to ask that you would recuse yourself from the obvious personal bias that you have against me and send us to master calendar for this scheduling of a trial.
And what personal bias is that?
A lot, obviously, the personal bias that you're showing right now and that you've shown on FTR several times during the trial.
Okay, well, I don't have any personal bias. All right.
She's like, the personal bias you've been showing all the time. He's like, can you give me an example? And she really can't. And he's like, I don't have a personal bias. Now she probably doesn't understand that he makes the decision here. Maybe she does understand that, but absolutely, Danny D, have I asked the judge to recuse themselves? Absolutely. Yeah. I've asked judges that I'm friends with to recuse themselves. Actually, I didn't ask. There's some judges I don't even ask to recuse themselves. We tell the other side, like, do you want this judge to recuse themselves? Sometimes there's very good reasons to. You do it appropriately. You do it in emotion. You do it with no disrespect, unlike here. This isn't how you do it. This is literally the opposite of how you do it.
Over accommodated you on when you have to disclose things. In fact, your expert should be summarily precluded today, and I haven't done that. All right. So
You denied every single one of my motions since for a year and a half that I've been here. Every single one of my motions has been denied. And have any of those motions not had merit? You've denied every single motion.
I think I was here this morning about 15 minutes ago when I granted your motion to meet with your attorneys over the lunch hour.
Can you tell he's smart? Like, he didn't know she was going to do this, clearly. There was not a written motion. She just sprung it on him. And he's like, okay, I'm going back into lawyer mode. It's me versus you. Let's do this. Where's my personal bias? That's not a personal bias. She's like, you deny every single one of my motions. Never say always and never, right? Even though I just said it. He's like, really? I seemed to be here 15 minutes ago when I granted your motion to be able to meet with your counsel at more and different periods throughout the trial and expanded that right for you. He's like, let's go. If you want to go, let's go. I'm trained in this. I've been doing this for a minute.
I have granted other motions of yours. Okay.
That's the first motion that you've ever granted
Well,
in my behalf.
file motions that have
You deny every motion. Okay, fine. That's the only motion you've ever granted. Pretty sure he's got some other ones in his mind that he could spin off if he wanted to, but he's like, this is not worth it.
a legal basis, and I might grant them.
So you're saying none of my motions have had merit?
Not many, no.
And none of the motions that my first team, you denied every one of my first team's motions. You denied every one of my second team's motions. And now you denied every one of my motions until today.
I haven't denied every one of your motions.
Every single one of their motions was denied. Every single one of the second team's motions were denied and all mine. So you didn't come into this with any bias against me in the first place?
Again, file a motion that has legal merit. Okay.
And none of my,
He's like, usually how you win legal arguments is you file a motion that has legal merit, which you have failed to do over and over again, including with this recusal. This is just not how you do it, Miss Vallow Daybell. VS, that's hilarious. Do it though. Crush law school. Crush law school. But yeah, it's like Lori. Listen. Do research, file the motion appropriately, and you may win. And you have won. And your prior teams have won. There's no way he has denied every motion. No way.
attorneys ever filed a motion with any legal merit?
File a motion that has legal merit. Okay.
And none of my attorneys ever filed a motion with any legal merit?
They filed a motion on your behalf, the first team, to preclude media coverage, and I issued my ruling according to the law. All right. They filed a motion to have you dressed out, not in jail clothes during hearings like this. Okay. That was not based.
And here he goes. He's like, let me rattle off some motions that you or your legal team have won.
in law. I denied that motion. So I've ruled on the motions as required by law.
Without any kind of conclusion of law in them, just denied, 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 denied. Does that not show a bias and a prejudice against one single person?
All right, are you done?
Actually, the way the law puts it is denying your motions or overruling your objections or sustaining the other side's objections is not enough for a recusal. And we saw this argued at length in the YSL trial with Judge Glanville, if you remember. And so she is just barking up the wrong tree.
Denied, denied. Does that not show a bias and a prejudice against one single person?
All right, are you done?
Are you not going to recuse yourself?
No, I'm denying your motion.
He's like, you done? No, I'm not going to recuse myself. Motion denied. Motion denied. I mean, he is having none of it. He is having none of it. And there's no jury. Yeah, the public is watching. He's not raising his voice. He's not yelling at. He's frankly not showing any personal bias. Maybe some annoyance, which basically every judge would have with every pro se defendant. I don't think he's going off on her.
All right, I was handed a motion to suppress all evidence pertaining to Jeep Wrangler.
I have not received that.
Did you probably got a copy of it today or not?
No.
Oh, do we need to make copies? All right, go ahead and make copies for the state. I also have a motion to dismiss for non-preservation of crucial evidence.
So I think that's what Chris was asking about. They haven't argued it yet. We'll see what comes out about it. They don't argue it in this hearing, obviously. And the state hasn't even seen it, which is, again, not really how it's supposed to be done, but we're in Lori Vallow's court.
Copy, I guess the state can file their response to those. All right, anything else for today from the state's perspective,
No, Your Honor.
from the defense?
No, Your Honor.
All right, we'll see everyone on the 29th at 1 p.m. Again, that's in this courtroom.